Few seconds to go. Yeah. So today we'll start with our lectures on polity that includes the Constitution. So what's polity? The entire political system. So what's the political system? Political system is about all elements of the society which are involved in power, who are acquiring power, subjecting others to power. So what is power? Power is making another person take up an action against his will. That means a person with power can make another person act in a manner that he dictates, even while the latter does not like it. What is authority? Authority is legal power. Today, if you are violent, it's because of your power. Tomorrow, if you are violent, it will be legal. When you are a civil servant, if you apply violence against anti-social element, it will be legal and that will be authority. So all elements in the society related to power and authority will be covering under the polity. And what's the place of Constitution in it? Constitution regulates our behavior towards individual and collective good. Remember, without Constitution, we were all in a savage society. We were acting according to our self-interest, our greed, our whims, our fancies. Might was right. Then over a period of time, a contract evolved according to which we agreed to conduct ourselves in a manner that is good for all, good for one, good for all. That contract took the shape of the Constitution and law. That's the background. Now let's see, what is the Constitution? You know, Constitution is the grand norm. Grand norm. That is, it is the basic norm. It is the basic norm. It is the fundamental law, sacred law, which is the basis for every other law. You know, there are many types of law. In olden times, we had divine law. We used to believe law came from God and heaven. It was given to a few individuals who said they were governing on behalf of God. That's divine law. Even today, we have what is known as customary law. That is law deriving from custom. The marriage, the inheritance, the adoption, they're all driven partly by custom. Over a long period of time, these customs have developed and we follow them because they have utility. They proved utilitarian and therefore we follow them. That's customary law. Some are good, some are bad, but we follow them. Then there is natural law. Natural law is, in each one of us, naturally, inherently, we have a sense of good and bad. And accordingly, we develop social behavior. We cooperate, driven by the law inside us, which is a part of nature. We are born with that. It's inherent to us. That is the natural law, the law that is there in nature that tells us what is good, what is bad. Then you have rule of law, which is the positive law. Positive law is man-made law through the government. That is the rule of law. People make law based on which the nation is ruled. That law treats everyone equally. It has the good of everyone in its consideration. It treats all equally. No one is above the law. Howsoever high you may be, law is above you. So rule of law is basically equal treatment of all according to law made by people. Equality before law. The law made by the government, the law made by legislature, the law made by the executive, they are all the components of rule of law. We'll come back to rule of law a little later. So since I use the term law, I had to tell you what is law. I told you what is law and the varieties of law. Remember, all these laws have to be compatible with the Constitution, which is the basic law. There is no possibility of any law existing that conflicts with the Constitution. It will be null and void. So let's see what is Constitution. It's the foundational law and it sets up institutions. It gives them power. It limits their power. It makes them check and balance each other. It gives us rights. It may even impose on us obligations. So let's try and see the meaning of each of the words we have spoken. Constitution, as I said, is the basic law. Who gave you the parliament? Constitution gave you the parliament. Who gave you the Council of Ministers headed by the Prime Minister? Constitution gave you, Article 74. Who gave you the President of India? Constitution gave you, from Article 52 all the way to 78. Who gave you the court system in the country? The Supreme Court, Article 124 till Article 145. Who gave you separate structure of government for the union and also for the states? Constitution. Who gave power to the union and the states? By giving you a system of federalism. I'll come back to federalism a little later. Constitution. Today we are all learning. I'm talking, you're listening. We have the fundamental right to speak, to express. You can sing. You can write poetry. You can meet. You can do business. Who authorized all this? Constitution. We have to respect each other. We have to be compassionate to all living creatures. Who told us? Constitution. I'm a citizen of India. You're all citizens of India. How do we know? Because we comply with the criteria of citizenship laid down in the Constitution, elaborated by separate acts. Those acts have to fall in line with the Constitution. Otherwise, those acts lose their value, legal value. They are invalidated. In other words, establishing institutions, giving them power, restricting their power, defining the relationship between one institution and another. For example, I talked about checks and balances. Parliament makes the law, judiciary strikes it down. Why? Judiciary is made the guardian of the Constitution by the Constitution itself. Judiciary has to protect the Constitution. If the Parliament goes beyond its limits, judiciary will push it back. That's called check and balance. If the Parliament makes a law, passes a bill, which the President believes is not acceptable, the President will veto it. President will check and balance the legislature. If a judge of the Supreme Court or High Court shows proved misbehavior or incapacity, Parliament will remove such judge. Check and balance. If the President crosses the boundaries of constitutional conduct, Parliament will impeach and remove him. What is impeachment? What is removal? We'll come back to later. So on and so forth. I have the freedom. I can speak whatever I like, provided I don't cross my limits. The limits are clearly laid down. So there is law that gives freedom to each one of us, and the same law also sets limits to the freedoms. All that is available. Article 19(1) is freedoms. Article 19(2) is limitations. Therefore, Constitution is the basic law which does all that we talked about. Basic law, grand norm it is called. And that being the Constitution, in some countries, Constitution is written. In some, it is unwritten. You'll all be wondering, those of you who may not have done political science or social science at all, you'll be wondering, how can a constitution be unwritten? Unwritten does not mean it is not written at all. Unwritten does not mean it is whispered around. No. Let me elaborate. A written constitution is one that, like Indian Constitution, all over the world, we have written constitution, except Great Britain, Israel, and New Zealand. So what distinguishes the written from the unwritten? Remember, in India, from 1946 to 1949, a dedicated body called the Constituent Assembly met, its members being elected and nominated. They were all experts, distinguished lawyers, constitutionalists. They all deliberated for approximately 3 years about each aspect of the basic law. And on the 26th day of November 1949, the Constitution of India was adopted, enacted, and we gave it to others. That is why you call it a written constitution, because a dedicated body of experts deliberating for a prolonged period of time, minutely about every aspect of the basic law, gave us this final product called the Constitution. So you call it written. Go to Britain, go to Israel, particularly Britain. From 12,015 1215. That was about 800 years back. You had Magna Carta in Britain. The nobles, that is, the rich people, told the king, "You're taxing us. We don't know how much you're taxing each one of us. You're spending money collected from us. We don't know how you are spending. There is no representation. You're conducting wars. You're not being fiscally responsible. Therefore, let there be a mechanism of representation so that there can be taxation. And associated with it, there is accountability." And that was Magna Carta, the Charter of Freedoms, representation, accountability, transparency. Since then, over the last more than 800 years, Parliament made laws and unwritten laws, conventions. We are doing it. It's utilitarian, so we continue to do it. So many conventions evolved. Laws are made. Rulings of the courts have taken place. And all of them together make up the constitutional base for British governance. Is it unwritten? Of course not. Why is it called unwritten? Because, like a dedicated body in India between 1946 and 1949 formulated the Constitution, there was no such event in Britain. And because it's a product of evolution, you call it unwritten. Almost all countries have written constitution. Israel was formed in 1948. They could not agree on the content of the constitution, so they gave up. And it also has unwritten constitution, which is a cocktail of laws made by parliament, conventions, administrative rules, and judicial verdicts. So written constitution, unwritten. Some people are saying, why not have unwritten constitution? It gives you flexibility. An unwritten constitution can lead to arbitrary governance, can lead to chaos, can lead to paralysis, can lead to suppression of citizen rights, because nothing is written. What is there to protect? In Britain, because of the long process of evolution, freedoms and institutions have taken deep root. Therefore, there, if you have a written or unwritten, it doesn't matter. But in a nascent democracy, like most of us in the developing world have, you need to have a written constitution. There is one more reason why we must have a written constitution. In India, some people have suggested, let's have unwritten constitution. We cannot. We are a federation. That means there is center with its own powers, states with their own powers. The center cannot walk into the state's territory and vice versa. And who told us about these federal rights? Constitution. Kerala and Chhattisgarh government have taken the union government to the Supreme Court, challenging some of the laws made by the Parliament. For example, National Investigation Agency. Chhattisgarh government took the union government to Supreme Court, saying that police is ours, law and order is ours. How can there be National Investigation Agency, which makes the state police secondary? It prevails over the state police. It takes up a case even if the state police doesn't agree. And they have gone to the Supreme Court saying it's unfederal. Who gave them the right? Constitution, a written constitution. A written constitution is the basis for federalism because you cannot write the rights of the federal units in water, in the air. You have to embody them in a permanent document called the Constitution of India. So you cannot have an unwritten constitution if the country has a federal democracy. America is federal. We are federal. Australia, Canada, so many other countries are federal. And they all have a written constitution. So, written and unwritten, I'm sure you have understood. I told you what is law. Law is made, I gave you different types of law, but we are talking about the positive law. And the only source of positive law is the government. Be it parliament, be it the executive. For example, you have Garib Kalyan, Anna Yojana. Who gave you the Yojana? Government of India, not the parliament. You have the right to information. Who gave you that? Parliament. So, Government of India, which is the ministers and the civil servants. Ministers are the political executive. Civil servants are the permanent executive. And sitting on top of them is the ceremonial executive of the President of India. They make up the executive. They can be the source of law. RBI made so many laws. That's the Government of India. Largely, RBI may be an independent monetary body, but it is a part of the Government of India, accountable to Parliament, accountable to the Finance Ministry. So whatever they do is law. It can be enforced. Enforced means it can be operationalized with force. Parliament makes law. Government implements it. Government is the only agency that has the authorization to use violence. Police uses violence. They have the right to use, it is legal in their hands. But before you become a police officer, if you use violence, then you are violating the law. So, law emanates, flows from the government, be it the central government, state government, local government, public sector unit, any wing of the government, any part of the government. Law flows from the state. State means, I need to tell you what is state. There is this word called state, and there is another word called state. The state of Uttar Pradesh, the state of Maharashtra, that is a federal unit, a province. That is a state. But all over the world, in the literature of political science, there is a term called state, nation state. What is nation? What is state? What is nation state? What is nationality? See, we're all Indians. Some of you belong to West Bengal, some to Sikkim, some belong to Madhya Pradesh. But we are all Indians. That is our nationality. We celebrate Diwali. We celebrate Eid. We celebrate Christmas. There may be different names to different festivals, but the logic is more or less the same. We have the same gods and goddesses, almost the same basic cuisine. So we're all Indians. Our nationality is Indian. We are Indian nationals. Over centuries and millennia, our culture has evolved and we all share it. So our nationality is Indian. And you see, all nationalities generally have a territory of their own. British, German, Afghans, Syrians, they have a territory of their own. Russians, Azerbaijanis. So there are people who are nationals making up a nationality. They occupy a certain territory. The territory belongs to them. They have a government that makes laws for the good of the people. The government protects the territory and the people through internal police force and external armed force. That government is recognized by global bodies like United Nations. And also we have organized economic activity. So people, territory, government, armed forces, and external recognition. These are the 5 features that make up our nation state. There can't be a state without a nation, but there can be a nation without a state. Take the case of Palestinians. They are a nationality. They lived together for millennia. They share the same culture, but they don't have a territory, nor do they have a government. They have a stopgap government in West Bank and Gaza, but it's not like the robust government that you have, that an American has. So Palestinians are not a nation state. Kurds are not a nation state. There are Kurds. They are a nationality, people sharing the same culture, but they have no territory of their own, nor do they have the government. So there are nationalities without a state, but there is no state without a nationality, because state is people, state is territory, state is government, state is recognition by the rest of the world. Palestinians may be recognized by others as a state, but that does not give them a state. Where is the ownership of territory? Where is the government? They are there because Israel allows them. And if Israel annexes the entire West Bank tomorrow, there is no Palestinian National Authority. So there is a nationality and there is a nation state. And the source of law preponderantly is the nation state, that is a state. But these days, in the modern times, we use the word state and government synonymously. But tomorrow in the prelim, if you are asked a question about one of the following properties doesn't belong to the state, you need to know what is state. You call it a nation, you call it a state, you call it a nation state, you call it a country, you are talking about the same thing. We don't have to differentiate among those words. You will ask me, for sure, we all belong to Andhra. We have our own culture. We have our dresses, our food, our festivals, our crops. Aren't we a nationality? We are sharing it for millennia together. Telugu is a classical language, that is ancient language. It's been there for more than 3,000 years. Are we not a nationality? See, there are cultures and there are nationalities. Andhra culture, Gujarati culture, Rajasthani culture, Indian nationality. We are a multicultural nation. And we can't even think of Andhra nationality. Some people say India is a multinational state. We cannot agree because we need to say it is a multicultural state. Once we say we are a multinational state, we are setting the stage for balkanization of the country. The country will break up into so many nations. We cannot accept. The country is like our body. We need to protect it as a single entity. Therefore, the way we describe India should be protective, should be sensitive. So we call India multicultural state, not multinational state. For that reason, because descriptions have vital material value in the way the nation evolves. So we have to be very cautious and wise in describing ourselves. So we know what is the Constitution. We know what is a law. Law is different from morality. Morality is good and bad, and it does not have legal backing. If you don't study well, your parents can't fail you. Your school can. If you are violent, you cannot be punished by your parents. Police can punish you. Courts can punish you. So morality, that is why in India we have this policy called prohibition. We are not allowed to consume intoxicating substances like alcohol in the country in some places. In Bihar, you can't. Some time back, in Haryana, you could not. Andhra Pradesh, you could not. Gujarat, even today, there is an official policy. So there's a debate. Should we have prohibition as a moral policy? Or should it be a legal policy? Both of them aim for the good of people. But certain things only morality can do. Certain things only law can do. That's a debate. Think about it. Now we have other words. We have words like bill, act, ordinance. We need to be clear about them. Later this month or next month, Indian Parliament will meet. Government will introduce many legislative proposals. Any member of Parliament can introduce a legislative proposal. For example, we need to stabilize our population. Let's have a law on that. Minister will introduce the bill, Rajya Sabha or Lok Sabha. A legislative proposal made in the legislature, that is Parliament at the union level, is called a bill with B capital. And each house will pass, goes to the president, president signs on it. It becomes act. And after that, it will be published in the Gazette of the government. Then it will come into effect. Till then, it will not come into effect. Even after the Honorable President of India signs on it, when it becomes an act, if the government changes its mind, it will not be published in the Gazette. It will not come into operation. So you know bill, you know act. What is ordinance? At any time when the Parliament is not in session, one house or both the houses, and there is a need to immediately make a law, we can't call the Parliament because the members are scattered across the country. Lockdown, No trains, no flights. How will they come? There may be war. How will they come? You can't summon them. We need the law today. For example, the health workers were taking all the risk in the world. But patients and their relatives and friends were very hostile to the health workers. They were violent, most shameful. Government had to bring an ordinance because there was no parliament. So President made the ordinance, promulgated it, that anyone violent towards the health workers are inviting punishment. If you had to wait for the parliament, it will not happen for a long time. So the president passed the ordinance, and that is also law. There is another phenomenon called subordinate legislation. I'm being very simple, extremely simple. 10th class. Subordinate legislation. Parliament makes the law. Let us say Parliament makes the law about a very technical subject called gene editing and the ethics. Parliament does not have the technical knowledge. So Parliament makes the basic law, and when it goes to the Department of Biotechnology, all the senior scientists there, along with the senior civil servants, under the leadership of the minister, they will add supplementary rules and regulations to the original parent law made by the Parliament. Those rules and regulations are called subordinate legislation, delegated legislation. They're all law. Tomorrow, when you are sitting in that office, and when you impose Section 144, you're not making law, you're implementing the law. You're enforcing it. You may add your own local rules to that, as demanded by the circumstances, which change all the time. They're all rules, sub-rules, law, and bylaw. Bylaw explains the law as it should be for a variety of circumstances. So a law is amplified by bylaws. They may be added to in the form of rules and regulations. They're all law. I told you there is so much of law that has not been made by the government. That is customary law. Government can't tell you how to dress, but your custom can tell you. On certain festivals, you dress up in a certain manner. That is customary. That's customary law. And it goes quite deep. In a developing country like ours, which is culture heavy, we have so much of customary law. As I told you, some is human, some is inhuman. The inhuman part is being weeded out by the judiciary from time to time. There was sati, customary law. Government abolished it. There is dowry, customary law. Government abolished it. There is instant triple talaq, customary law. It was there in the positive law also. Sharia, 1937. Government abolished it. Instant triple talaq. So you have the customary law being brought in line with the Constitution of India, which is the embodiment of humanity, morality, progress, security, freedom, social progress, and spiritual progress also. We are proud of our Constitution. Now let me go into the concept of constitutionalism, and from there we will go into rule of law. Constitutionalism, if you look around, all the countries are governed by the basic document called Constitution. There is a philosophy that says that governance should be based upon Constitution. And the Constitution, as it sets up the government, should also limit the government. Government is a double-edged sword. It can liberate us. It can also oppress us. Go to so many countries. Government may not be a friend of the people. And go to so many other countries. Government is a source of security and freedom, progress and prosperity. That's because Constitution enables the government as much as it limits the government. If it doesn't, you have the authoritarian government coming up. And government exists for the people, not the other way. So constitutionalism says that a basic law called the Constitution must be formulated. That should be the basis of governance, and that should give power to the government. That should empower the citizens as well. And most importantly, it should be a source of limitation of the power of the government. Limitation. I want to speak. I don't want anyone to interrupt me. Who gave me the right? Article 19(1)(a). If there is an offline class, we all congregate. We have a class. Who gave you the right to travel? Article 19.1. Who gave us the right to associate ourselves? Article 19.1. And when you are silently reading your textbooks, the book you choose, right to privacy. The time you choose, right to privacy. Will you read a hard copy or will you read the Kindle copy? Right to privacy. All of them are built into the Constitution, and this Constitution limits the power of the government to interfere with our fundamental natural rights. Nature gave us rights. Constitution only recognized them. So Constitution has to give us rights and help us to enjoy them and limit the power of the government to protecting the rights but not depriving us of the rights. Article 21, right to life. We have always had. Constitution came into being on the 26th of January 1950. We had the right to life before that. 1,000 years back we had. 3,000 years back we had. It's a natural right. Constitution gave it a legal shape, and Constitution gave the government and the courts the power to protect our natural right. Constitution enables the government as well as limits the government. Limit the government. Because the government has enormous powers. They can be a source of freedom. They can be a source of oppression. That is constitutionalism, which is a universal modern political philosophy, democratic theory. Now let's see what is rule of law. Rule of law, which is a basic feature of the Constitution, according to the Supreme Court in the Keshavananda Bharati case verdict, 1973. What is rule of law? Rule of law is a philosophy that says that all are equal, no one is above law, and governance cannot be whimsical, arbitrary. It has to be based on law that provides equality to all of us. Who made the law? We made the law. Lord Dicey is associated with it. Rule of law that provides equality, protects equality. A very interesting aspect of rule of law is, very important, law does not create rights, as I was telling you a few minutes back. Law only recognizes rights. We protected lives. We had the right to life even before the law came into being. We had liberty. We had the right to property. We even had privacy. Law only recognizes them to be important and gives them a legal foundation so that courts can protect, individuals and groups can claim them. In other words, law doesn't give us rights. Law recognizes the rights and enforces the rights, protects the rights that were there even before the law came into being. Natural rights. Law only gives it a legal form, enforceable form. In nature, your right to life could not be protected with reference to a common instrument. There was morality, but there was might is right, law of the jungle. Today there is civilized society. The basis of our civilized conduct is law. Law gives you predictability, transparency, accountability, consistency. That's the majesty of law. And the law only mirrors the natural rights you had and protects them. That's the most important part of the rule of law of Lord Dicey. There are other aspects. We can take up 2 or 3 of them right now. Law is made by one authority, implemented by another authority, judged by another authority. You want to be civil servants. In the Criminal Procedure Code, you had powers. Tomorrow you will become executive magistrate. You not only implement the law, at one time you did, and if anyone had to question the implementation of law, they had to go to the same authority that implemented the law. That is violative of natural justice. What is natural justice? In natural justice, the one judging should not be interested in the case. If you implement the law, and if I have a problem with your implementation, if I have to come to you, am I assured of justice? You will support yourself? I'll be denied justice. So CRPC divested the district magistrate of some powers of adjudication and gave them to the courts, judicial authority, So you implement the law and they will judge whether your implementation is right or wrong. In which case my freedoms are protected. That is also rule of law. Otherwise, you may have the best of laws, but if the mechanism to enforce and protect them is faulty, citizens will still be at risk of injustice. Similarly, unless there is separation of powers, Parliament makes the law, executive operationalizes them, and the judiciary adjudicates upon them, there cannot be rule of law. If the Parliament makes the law, executive implements it, executive is under the control of the legislature, therefore it cannot go against the legislature. And if there is no judicial protection, how are the citizens safe? Unless the president has the power of veto, how can the legislation be robust? Unless the judiciary has the power of nullifying a law, how can there be rule of law? You will have rule by law. Rule of law is democracy, rights, equality, expansive freedoms, and so on. Rule by law is you are ruling by law. Any law is law. You are ruling by law. The law doesn't give you freedom. The law is not transparent. No questions are allowed. No answers are given. That is also law. But that is completely incompatible with the letter and spirit of rule of law, which expands freedoms. Rule by law is there is a law, based on that you are governing, but that law has no properties of democracy and freedom at all. You must have seen some legal experts differentiate between rule of law and rule by law. Who knows, it can come in the exam. Because rule of law, the philosophy, is the basis of modern civilization, its development, and its prospects. So you know the Constitution, you know constitutionalism, you know the rule of law, you know varieties of law. We also talked about freedoms. Since I use the word freedom and liberty, I need to differentiate between the two. You know, liberty and freedom are largely used synonymously, but we as students of Constitution and Indian polity, we need to differentiate because the question did come in the exam. Liberty is absence of restraint. There are no obstacles. For example, you can dress the way you want, read what you like, go for a film of your choice, and carry a mobile, not carry a mobile, visit Wikipedia or BBC or the President of India website, all this. If there are no constraints, you are at liberty. After that, you exercise your freedoms. What are your freedoms? You want to speak. To speak, you must not have any constraints. To travel, to associate, to do business, to settle down, to pray. All of them are your freedoms. You are free to pray the God of your choice, the place of your choice, time of your choice, the duration of your choice, the wish of your choice. You are private in all these matters. So there are no obstacles to your freedom. Not having any obstacles is called liberty. Once there is liberty, you have all the freedoms that I had just now described. So freedom requires liberty as a precondition. That's how they are related. So you know the liberty, you know freedom, and now we also need to talk of a few concepts as a introduction to our polity before we move into specific chapters. You have heard of concepts like sovereignty, socialism, communism, republic. All these you've heard about. And we can't be vague about all of them. Everyone talks about them. But you need to be concrete. You have to have the clear meaning, dictionary meaning, the consensus meaning, clear terminology, precise terminology, not ambiguous. So let's try and get the meanings of these words. You can use them in your own words. You can talk the way you want. But underlying your talk should be clarity of the meaning of these words. Very, very clear. Unmistakably clear. So what is sovereignty? Sovereignty is, as I told you about the nation state, every nation state is sovereign. There is no authority above the state, either inside the country or outside the country. Inside the country, the government is sovereign. There is no one above the government. Constitution is sovereign. Constitution gives sovereignty to the state. The state is sovereign. Who made the state sovereign? That is the inherent property of state. Where is it recognized? Constitution of India. Is there no one above the state? No. Who is the state? What are the components of state? I already told you. Parliament, executive, and so on. It's defined in Article 12. We'll get there. Again in Article 36, the same definition. We'll get there. But in the meanwhile, that is the government. Let's say government for all simple purposes. Let's say government. Government is sovereign. There is no one above government. Is Parliament sovereign? No. What the Parliament does, the President can say no. Supreme Court can say no. High Court can say no. Is the Supreme Court sovereign? No. Parliament can say no. A larger bench of the Supreme Court itself can say no. So Supreme Court is not sovereign. Is the President sovereign? No. The presidential order can be defeated by the Supreme Court or the Parliament. But all of them make up the state and they are sovereign. No one is above them. United Nations is not above them. We are a member voluntarily of the UN, of the World Trade Organization, of the IMF, of the World Bank, of the Asian Development Bank. So we have volunteered to accept certain obligations in these bodies. You want to come out of it, you can. So neither inside the country nor outside the country there is any body or authority above the government of India. That's what makes the government of India, Union of India, or government, let's say government. It can be state government, local government, government, state, sovereign. We were a colony. We were governed by the British. The property of sovereignty was there in the Indian state. and it was exercised according to the wishes of the British government because we were not independent. Now we are independent. The sovereignty of the Indian state is a function of the people of the country. We are a democratic state. So a colony, the state was sovereign, but it was not an independent country, and therefore sovereignty did not work for the country as it suited the people of the country. That is sovereignty. In Commonwealth, we are sovereign. We have chosen to be member of the Commonwealth. It's another thing, the British monarch is the head of Commonwealth. If you don't like to be there in the Commonwealth, you come out. You want to be there, you be there. It's a sovereign decision. No authority inside or outside can command the government to act in a certain manner. But at times, the sovereignty of the government may not be respected by the international body, United Nations. What's the example? In case a government is suppressing its people, violating human rights, killing its own people, and has failed to protect people, then the United Nations can authorize its members to intervene and set the matter right. That was adopted 15 years back by the United Nations, what you call, you have to intervene in a country to set it right. That was about 15 years back. Responsibility to protect it is called R2P. So the global community has the responsibility to protect. If China suppresses the Uyghur Muslims in Xinjiang province, who knows, tomorrow the world may unite to liberate them from Chinese oppression. It's possible. That will be R2P. What happens to the sovereignty of China? Your sovereignty cannot be misused. The world has a responsibility. You are a member of United Nations, and they have a responsibility to ensure all members behave according to the Charter and the Universal Rights Charter also. That is sovereignty. What is socialism? How is it different from communism? Socialism does not have a single meaning. You have Gandhian socialism, which is completely different from Nehruvian socialism, which is different from certain global notions of socialism. Socialism is simple. When the government owns the means of production, land, labor, capital, and enterprise, you call it socialism. Government has to own. How much? Greater or smaller extent. Today in India, government owns railways. Government owns some companies. Government owns posts and telegraphs. So we are a socialist country. Why does the government own? Government owns because if it is left to private ownership, it will create huge inequality, monopolies that can sharpen inequality. There may not be employment. There can be mass poverty. So when the government owns railways, people are able to travel affordably. You have a type of equality. That is socialism. What is communism? If the government owns the entire economy, If there is no right to property, then you call it communism. Socialism allows private property. In socialism, the government doesn't own the entire economy. In communism, the entire economic resources are in government hands and you have no private property. All that you grow in your kitchen garden, either you have to consume or you may have to give it to your neighbor, but you must not charge for it, cannot sell it, because when you sell it, it becomes an economic activity, and that is denied to every other agency except the government. So communism and socialism. Now you will ask me, how do you differentiate it from welfare state? Let's go to America. America is a welfare state. The welfare of the people is the responsibility of the state. You get social security, education, health, and other benefits, unemployment benefits. We are also a welfare state. We have Mahatma Gandhi National Rural Employment Guarantee Program. We have Garib Kalyan Anna Yojana. We have the public distribution system. So we are a welfare state. We have Kisan Samman Yojana, direct benefit transfer to them. We are a welfare state. Socialist government is usually a welfare state. But welfare state need not be a socialist government. Why? American example. America doesn't have socialism. But America is a welfare state. We are a welfare state. We are also a socialist constitution, economy. What kind of socialism do we have? Do you follow any doctrine? No. Our socialism is called socialist pattern of society. We have directive principles. We have protection for certain castes, certain ethnicities. Now you also have economically weaker sections protected. So this is the Indian model of socialism where we have to respond to the unique social conditions of India. For example, caste. We had this atrocious institution of caste. We had to level the society. We need to give reservation. We need to take affirmative action. We need to elevate the status of women. All the policies meant for leveling the society with government welfare intervention, they make up the Indian model of socialism. You call that socialist pattern of society. So you know sovereignty, you know socialism. What is a republic? A republic is a country where the head of state is not a hereditary institution. He may be elected directly. He may be elected indirectly. He may even be appointed, but his children have no claim on the institution. It's not a monarchy. It's not hereditary. That is what makes it a republic. Republic means public. When the entire public is eligible for all posts in the government and outside, you call that a republic. Republic and democracy generally go together, but not always. Britain is not a republic. They have a queen. Tomorrow they may have a king. But Britain is a robust democracy. All republics need not be democracies. You can have a military establishment where the head of the state may be appointed and may be elected also. But they are not a democracy. A republic need not be a democracy. A democracy need not be a republic. So you can be one without the other. So these are some of the terms on day one that we had to acquaint ourselves with as a part of the discussion about what is constitution, what is law, bill, act, ordinance, delegated legislation, what not. These are all very simple. While listening to me, you must have remembered your NCERT books of the 10th class or 12th class. NCERT means conceptual clarity, right amount of facts, and rational thinking, democratic thinking. So that was what is a constitution, what is constitutionalism, and so on. That guides us to the next chapter. And now we are getting into the Constitution of India. We are through with our introduction to the polity. Polity, how is it different from the Constitution? In the whole Constitution of India, you don't have a discussion of pressure groups. There are pressure groups. Federation of Indian Chambers of Commerce and Industry, FICCI. Industrialists are there. They are a pressure group. They put pressure on the government for a certain policy. They may pressure the government to adopt the policy of Atmanirbhar so that they will have no competition. They can make them in the country and they can tomorrow emerge as multinational corporations. Caste groups are there. They put pressure on the government for a variety of concessions. Women make up a group. Trade union of workers are there. Peasant groups are there. They're all there because Constitution allows. They're a part of the polity. Their actions decide about distribution of power. A caste gets a reservation. Its social standing improves. Its power improves. Minorities get additional rights. They feel more secure. The power relations change. Political parties, they're not in the Constitution. So they all make up the non-constitutional side of the polity. Now let's move to the next chapter called Outstanding Features of the Indian Constitution. Outstanding features. You can't call them basic features. I'll tell you why. You can call them highlights, salient features, key features, any other term you can use. But basic features you cannot. Why? Because in the Indian constitutional evolution, constitutional law, that is all the judgments of the Supreme Court and High Courts that have developed the Constitution of India through its interpretations, That's called the constitutional law. The judicial additions to the Constitution is what you call the constitutional law. In that, the concept of basic features has a special place. In 1973, a landmark judgment of the Supreme Court called the Keshavananda Bharati case. Landmark means a new principle of interpretation of the Constitution has been introduced. That is what makes the ruling a landmark ruling. In that verdict, the Supreme Court introduced the concept of basic features. They felt that some features of the Constitution are permanent, immutable, they cannot mutate, embedded in the Constitution. For example, can anyone ever see sovereign, secular, democratic, republic, rule of law, justice, equality, federalism, independence of judiciary? Can at any time in future, will at any time in future, these concepts become redundant? I can't see. Unless after thousands and thousands of years, optimistically, we don't even need the Constitution. We behave with each other like brothers and sisters. We are not talking of that time at all. As long as there is Constitution, these features define the Constitution. They are the building blocks of a civilized society, civilized India, and thus these features are basic features, embedded features, organic. And so, we are going to describe the outstanding features. They may overlap with the basic features, but they may not overlap. So, if you say they are the basic features, the examiner is likely to fault you. Let's not make that mistake. So let us see the salient features of the Constitution of India. Some people say, can we say Indian Constitution? Should we not say Constitution of India? Yeah, ideally you should say COI, Constitution of India. But as we talk, as we write, at times we say Indian Constitution. It's okay. There's no mistake there. In fact, in your economical style of presentation, COI is 3 words, assuming you are counting off. And Indian Constitution is only 2 words. You're saving on words, manual effort, without compromising on the meaning. So we don't have to be held back by these. I would think they are trivial differentiations. So there is a series of features that make up the fundamental features of the Constitution. One is, our Constitution is the most voluminous in the world. There is no other constitution in the world belonging to a country which has so many articles. We have originally 395 articles we started with, 8 schedules we started with. Today, After 104 Amendment Acts, we have approximately 450 articles. And we have 4 new schedules added. We have 12 schedules. So with 450 articles and adding to them schedules. Now, you're waiting for me to explain to you what are schedules. You know, schedule is a part of the Constitution. It has homogeneous features. It extends from the Constitution. Let me explain. Today, we have 28 states and 8 union territories. Remember? Dadra Nagar Haveli and Daman Diu, they are merged into one. So we have states and UTs. Jammu Kashmir was a state at this point of time last year. Not anymore. It's become 2 states, 2 union territories now. Where do you find them? Where do you find their names, their areas? You have to have a place in the Constitution. So you have the first schedule for that. You have the Panchayati Raj and Nagarapalika. Panchayati Raj and Nagarapalika. All the 29 powers that the panchayats may be given by the state legislatures have to be in one place. It can't be an article because it can be an article, but you have chosen to make it into a schedule. Nagarapalika, another schedule. There are about 100 subjects given for union government, about 61 or so for the states, about 52 for the concurrent list. Where do you find them? You find them in the 7th schedule. So I told you, schedule extends from the Constitution. It's a part of the Constitution. It contains homogeneous features. States and some UTs with assembly have their members in the Rajya Sabha. How many? That's all contained in the 4th schedule. You have to consolidate them and contain them in a single place. It has to be distinct from an article. So you inaugurated the schedules. They are a part of the Constitution. All the articles of the Constitution from 1 to 395 and all the articles in between, A, B, C, D, you have them serialized into 25 parts. Serialization. Article 1 to 4, 5 to 12, 13 to, you can go up to 35, 36 to 51. So what do the articles 36 to 51 make up? Directive principles. Before that, fundamental rights. Before that, citizenship. Before that, union and its territory. After DPSPs, you have the duties. So all the articles 1 to 395 are collected and kept in serialized parts, part 1, 2, 3, all the way to 22, along the line A, B. So when you put it all together, you have the most voluminous document governing any country. You call that a constitution. And there are reasons why we are the most voluminous. There are so many reasons. One is we have borrowed from so many countries the idealism, the perfectionism of the Constituent Assembly made them borrow from many countries. You borrowed from America, Britain, Ireland, France, Canada, Australia, Weimar Republic, Germany in the 30s, South Africa, and later you borrowed from USSR, the erstwhile USSR. You also borrowed from Japan. So when you borrow so many features from so many countries, surely it adds to the length of the Constitution, and that's one reason why you have the lengthiest Constitution in the world. So what have we borrowed? Let's see. From UK, that is Britain, you borrowed rule of law. That is the country where the rule of law was born. You also borrowed parliamentary democracy. I'll come back to the concept of parliamentary democracy a little later. You borrowed a ceremonial head of state. Remember, there are two terms here: head of state, head of government. You have the British monarch, you have the Indian president. They are the head of state, heads of state. They are ceremonial largely. They have some power, but largely they are ceremonial. Indian president has more power than the British crown, but still it fits into the description of being a decorative office, ornamental office. Though we'll dispute it when we come to the chapter on the President of India. They're called head of state. They are there for a certain reason. The reason is different for Britain and India. To some extent, it's different. In Britain, they continue with the crown for historical continuity, its unifying nature, collective memory, and also as a source of stability. In India, we have the President of India to send a message that we are a republic, and also to operate with real powers in certain circumstances. We can't do without the president. We need the president, but only under certain circumstances. And for politically neutral governance, for stability, for constitutional continuity, for impartiality. So we have a head of state, but we have the head of government, like in Britain, in India. The Council of Ministers headed by the Prime Minister, Article 74. They are the head of government. They govern in actuality, de facto. Ceremonial is de jure. All the functions of Government of India are carried out in the name of the President, but only in the name of the President. De facto, de jure. So, in India, the institution of presidency, which is a ceremonial institution, and the institution of the Prime Minister heading the Council of Ministers, You don't have to have both of them. You don't have them everywhere. In America, you have the president who is the head of state, head of government. But in India, this differentiation has its own utility, and we borrowed it from Britain, who were our earlier masters. What did we borrow from America? We are a federal country, we borrowed it from America. Their president is also indirectly elected like our president of India, that our president. But there is substantial difference. At the mechanism level, yes, they and us, we have the same mechanism as far as electing the president is concerned. Fundamental rights are modeled after the Bill of Rights of the American Constitution. They have a bicameral legislature. We also have a bicameral legislature. One of them is federal. Ours is also Rajya Sabha is federal. They have judicial review. We have judicial review. But judicial review is invariably associated with the notion of federalism. So to say that we borrowed federalism from America is right. But to say that we also borrowed the federal court and judicial review, that goes without saying. You may say it. It's up to you. From Ireland, we borrowed directive principles of state policy. Ireland borrowed them from Spain. We borrowed from Ireland. And they are the conscience of the Constitution. They are instruments of instruction to the government and to all other organs of the state to govern with an ethical foundation. There is Canada. We borrowed a strong center within the system of federalism from Canada. Residuary power, that is, see, in the seventh schedule, as I told you, the powers, the subjects of the union government, the state government, and both of them in the concurrent list are there. You can't think of every subject at the time of formulating the Constitution. For example, disaster management. It's not there in the Constitution. Even if you know, you may not include it. Religion is not there. Environment is not there. Where do they go? Tomorrow, who will make a law on that? These subjects which are not specified in the seventh schedule into any one of the three lists, they make up the residuary legislative power, and that power goes to the Union Parliament, and that is a feature you found in Canada and you borrowed it. When you go to Australia, you have taken from Australia the concept of concurrent list, that is, the union government and the state government. Union legislature, state legislature. Both can legislate on these subjects with certain rules. You borrowed it from Australia. Also remember, for every bill to be converted into an act, it has to be passed by the Parliament. Both the houses, except the money bill of the Parliament. In case the two houses don't agree, you have to call a joint session. The president may call a joint session. This is a concept we borrowed from Australia. Amending the Constitution we borrowed from South Africa. Emergency powers from Weimar Republic of Germany in the 30s, when Hitler was there. We borrowed liberty, equality, fraternity from France. There is a concept called procedure established by law. That is, there is law, in that there is a procedure. While implementing the law, if the procedure is followed, then the implementation is valid. This we borrowed from Japan. So we have borrowed so many features from so many countries. And finally, most recently in 1976, we borrowed the concept of fundamental duties, incorporated that in Article 51A. We borrowed it from the Union of Soviet Socialist Republics, USSR. The country does not exist. It disintegrated in 91. Its inheritor largely is Russian Federation today. And there is all these features from so many constitutions have added to the volume of the Constitution. That's not the only reason. There are so many other reasons. From the 1935 Government of India Act, we have inherited so much of Constitution. And there are many more reasons. Take fundamental rights. From Article 12 to 35, and within that in Article 15, 16, Article 21, there are so many articles added by amendments. We want to be a democracy, a thriving, throbbing, contemporary democracy. And the heart and soul of democracy is the list, the vital list of freedoms. And so, having chosen to incorporate fundamental rights, we should be ready to see a very lengthy constitution. And then go ahead. There is directive principles of state policy. Articles 36 to 51. Along the line in 39, you have additions, 43 additions, A and B. 48, you have additions. So you want to have a welfare state, a moral state. You need to have the DPSPs. So you have to be ready to have a lengthy constitution for it. And then you come to the fact that we are a federal country. You have an entire union government, president, parliament, and Supreme Court. You have an entire state government, governor, state legislature, and high courts. They take up more than 100 articles. Beginning from 52, you go well into the 200s. That also adds mightily to the already existing volume of the Constitution. So you have the length. And then you talk about the diversity. We are very, very proud about the diversity that we protect and promote within India because we are a rainbow country. We protect by caste, by religion, by ethnicity, by language. We are proud of our diversity. That makes us rich, meaningful, forward-looking. So, But in the process, we have added to the Constitution. We have added 29, 30, and so many other articles. And also, unlike other countries, we have a local government with a constitutional status, an entire article, Article 243, within that so many provisions. The 11th schedule, the 12th schedule, they're all because of incorporating the local self-government institutions. Article 40 is about them. Article 243 is about them. That's another reason. Still another reason. Please feel proud about the vision of the makers of the Constitution. We have Union Public Service Commission. We have the Comptroller and Auditor General of India. We have the Election Commission. And we have other regulatory agencies. All of them are a part of the Constitution. That shows how much value we attach to the bureaucracy, the electoral process, the answerability of the government to an independent regulator. All this, being a part of the Constitution, has added volume to the Constitution. And as you are here with the Constitution, and there is one more reason. 104 times the Constitution has been amended. The most recent amendment, 104, is about extending reservation for SC/ST in the representative bodies, state legislature, central legislature, and dropping the reservation for Anglo-Indians. The one before that added a new article. It established National Commission for Backward Classes as a constitutional body. The one before that, that was economically weaker sections. And the one before that is about National Commission for Backward Classes. That added an article. Economically weaker, that added an article, which is 103. 101, which is the GST, has added so many articles. Anti-defection law added. So with so many amendment acts, you have large amount of additions to the Constitution of India, bringing us a total of approximately 450 articles. Are we better off? Yes, why not? Have we been fickle-minded? Of course not. Why did we amend so many times? Because that is necessary. You have yourself seen. Reservation for economically weaker sections is necessary. GST is paramountly necessary. We had to give enclaves to Bangladesh and we have to reclaim our enclaves, our territory, their territory. Exchange of enclaves. Necessary. There is only one amendment act that has been completely struck down by the Supreme Court, and that is the 99th Amendment Act concerning the establishment of National Judicial Appointments Commission. Supreme Court did not approve of it, and so it's been completely nullified. Otherwise, operationally, we have 103 Amendment Acts. One of them has become a dummy because the Supreme Court completely disapproved of it. Now, so we have elaborated on the reason for the reasons for the Constitution of ours being the lengthiest in the world. Another outstanding feature of ours is that we have a parliament which is supreme but not sovereign. We have a parliamentary democracy. You know, parliamentary democracy has a specific technical meaning. It means the political executive is a part of the legislature. Democracy is democracy. Democracy means rule of people, that is the electorate, electing their representatives based on the principle of universal franchise. The representatives make up the legislature. They are the ones who make laws, and the laws are adjudicated upon by the judiciary, which is independent. You have freedoms given to the citizens. You have rule of law. And you have a civil society. That is, there is a technical meaning to civil society. Family is a private body. State is a political body. All the organizations and groups in between make up the civil society. Pressure groups, NGOs, media, even great personalities. For example, Loknayak, Jayaprakash Narayan is an institution. He is not an individual. Ram Manohar Lohia, Mahatma Gandhi, they are not individuals, they are institutions. They make up a part of the civil society. So family and the state, one is private, the other is political, and what comes in between is your civil society. All of them make up a democracy. But within a democracy, you have parliamentary democracy, you have presidential democracy. Parliamentary democracy is where political executive is a part of the parliament, that is legislature. In other words, all ministers have to be members of the legislature. If you are not, you are given grace time within which you have to find a place in the legislature, or you have to quit the post of the minister. 6 months time. Maharashtra chief minister, he became chief minister. He was not a legislator. He had to find his way into the legislature through the legislative council. Bihar chief minister. So many others. Earlier also Maharashtra chief minister, Mr. Prithviraj Chauhan. From the center he went to the state, had to become a member of the legislature to retain his post as a chief minister. Go to America, it is exactly the opposite. The political executive should not be members of the legislature. Trump was not. Obama was not. Obama had to resign. Hillary Clinton had to resign. So that is presidential separation of the legislature from the executive, goes to an extreme level. Whereas in a parliamentary democracy, that separation is non-existing as far as the executive and legislature, the executive being a part of the legislature, that shows that separation of powers to that extent is muted. Now, we are a parliamentary democracy. Parliament has enormous powers that makes it supreme, because supreme is less than sovereign. Sovereign means there is no authority higher. If Indian Parliament was sovereign, there'll be no authority above Indian Parliament. But surely, the laws made by the Parliament are open for judicial review and part or whole invalidation. Also, when a law made by the Parliament, the bill passed by the Parliament can be vetoed by the President, how can you say the Parliament is sovereign? The Parliament has only one list under its control, Union list. The other list, there are conditions attached, concurrent list. So how can it be sovereign? It can't legislate on the state list normally. So when the legislative capacity of Parliament is limited, when its capacity to amend the Constitution is limited, because some parts of the Constitution to be amended require ratification by half the states. Legislative limitation, constituent power limitations, basic structure is a permanent limitation, presidential veto is a limitation. So how can Indian Parliament be described as sovereign? It's not sovereign at all. It is supreme. It has made so many laws. It has made so many amendments to the Constitution. It can impeach the president also for violation of the Constitution. It can remove constitutional dignitaries. Thus, it has enormous powers. But that is not equal to sovereignty. There are limitations on the power of the Parliament. So it becomes supreme but not sovereign. So parliamentary democracy, where Parliament enjoys enormous powers to point of being supreme, but it is not sovereign. That's another outstanding feature of the Constitution. Still another outstanding feature, you may call it salient feature, is we are a federation with centralization. Unitary tilt, you may call it. I would like to clarify it once and for all. Some people want to call it a unitary country with a federal features. Some call it a federal country with unitary features. But only the second expression is right, not the first one. We are a federal country and there are unitary features. Then you will ask me, how can you be so categorical when senior pundits have called Indian Federation as not a federation but essentially unitary with federal features? The demarcation, the divider between a unitary system and a federal system is the following. In a federal system, the litmus test to a federation, whether it's a federation or not, is the following. If the union government, you may call that national government, federal government, or central government, as it suits you, and the provincial governments, that is the regional governments or state governments, when they have their independent list of powers, there is a union list, there is a state list, and each is supreme in its own domain, normally. And if the same is built into a written constitution, you have to call that constitution a federal constitution. You cannot have your own liberties of expression. There is a distribution of powers. That is division of powers. Some powers go to the union, some powers go to the states, and that is said in a constitution, which is a written document, and the judiciary is there to protect it. They will ensure no trespassing by either government, either level of government. Then you are looking at a federal constitution, and that's the only name that fits that constitution. In a unitary constitution, states enjoy powers at the discretion of the union government. For example, today, Chhattisgarh government took the union government to the Honorable Supreme Court, challenging the law made by the Union Parliament with regard to the establishment and powers of the National Investigation Agency Act. Who gave Chhattisgarh power? State list, 7th schedule, Article 246, Article 131 enables the federal units to pull each other to the Supreme Court in defense of their rights. So division of powers, which is also the same thing as distribution of powers, in a written constitution and protected by an independent judiciary at the national level, federal level, is what nails it as a federal constitution. And as I told you, the power enjoyed by Chhattisgarh at the discretion of the union government, here today, gone tomorrow, is a unitary government. And that's not what we have in the country. So you have to necessarily, compulsorily call our constitution a federation. You may qualify it unitary tilt, centralized, and so on. Quasi, that is, seems like, looks like, resembles. Quasi. You may call us quasi-federal. But it is federal. There's no other term for it. It is federal. So we are a federal constitution, but if you look into the features of the constitution, provisions of the constitution, as far as the core features of federation are concerned, you will see so many features of a federation you expect in the Indian constitution are absent in the Indian constitution. And that is what gets you the title that you are a quasi-federation. There are so many features. For example, 1 year back, there was a state called J&K, Jammu and Kashmir. Today, it is 2 union territories. And the opinion of J&K did not matter at all. Parliament decided. President allowed the parliament to decide. And you have changed the status of the state, both territorially as well as from a federal perspective. Is this federal? No pundit of federalism, no minimal understanding of federalism will allow you to call our constitution federal after that. But is it not necessary? Should we secure the nation or should we be federal? If there is a conflict, you have to secure the nation. So bifurcation of J&K was the need of the hour, according to the government, given the knowledge of the state that they had, and they had to overrun the wishes of the state if need be, as was the case for national security, without being sensitive to federal necessity, federal nicety. Necessity. So yes, we are unfederal there. You may even say anti-federal, because a core feature of the federation is that Just as the union cannot be broken up, no state can also be broken up. The territorial integrity of the state is sacrosanct. Indestructibility of the union, we are all together, nobody can destruct us. Identically, indestructibility of the state cannot be broken up either, bifurcated, trifurcated. No, it can't be. But that principle has been departed from. Why? That's the story we will get into tomorrow. This is what we could discuss today. We'll keep going. Now the time has come for you to ask me questions. Don't hold back. You can shoot. Yes?
Hello, sir.
Yeah.
So I had a question regarding the thing we were discussing about the schedules that the Panchayati Raj system was, means the provisions were given in the schedule. So I had a question, like basic question: how is there any distinction that determines if the thing is to go into constitution or it has to be made as an act or something? Is there a proper distinction? Means could there have been a Panchayati Raj Act which had all the provisions of that?
See, you have all the flexibility. You can choose to make it into a schedule. You can choose to put it into an article. For example, anti-defection law, 10th schedule. It connects so many articles. So you have to necessarily make it into a schedule. Which article can possibly accommodate the first schedule where you have all the states and the UTs, the names, the areas. That will make it cumbersome. The smooth flow of the articles will be interrupted. So it is far more convenient to have a special place in the form of schedules.
But sir, would it not decide the future of that thing, like how it will be in the future, how it will be amended? If it is an act, then it can be amended in a different way. If it is part of constitution, then
You know, in the original constitution, you had only 8 schedules. You found a need for 9, 10, 11, and 12.
yeah.
And for certain reasons, tomorrow you can have 13, 14, 15. That's the sovereign, that's the power of the parliament. They will decide. After all, there is no iron law here. You are flexible. If there is room for a schedule, there'll be a schedule. Otherwise, there'll be only addition to the article. If there are so many rules about, say, economically weaker sections, you gave them reservation. You could have converted it into a schedule also, but you chose Article 15 and 16, addition of additional articles to that. But you could have inaugurated a schedule where you could have loaded all the relevant rules and regulations. They're completely flexible. Another question I have here through the Q&A box: what about historical background and acts in it? See, historical background has to be covered as a part of modern history. Because unless you know about what happened since the 18th century, how the laws evolved, how the crown took over from the company, and so on and so forth, why they came about, in what form they came about, what is the political context of it, what is the external context, you won't be able to make sense of it. So, Constitution is independent. It can be studied independently, and the historical evolution of it you'll be able to understand when that relevant portion of history has been covered. That is why in the notes of the Constitution I have given you, we have not begun with history. historical evolution, that will be added in course of time when the historical side of it is covered by my colleague dealing with Indian history. At any rate, Constitution is independent. Everything I told you stands in its own right. Differences between socialism, communism, welfare state, once again. Communism is complete ownership of the economy by the government. There is no private property at all. All economic resources, even your labor power, is owned by the government. Socialism is portion of the economy is held by the government. Rest is in private hands. You call that mixed economy. Welfare state is the government may not own any economy at all, but your social security and your welfare, particularly that of the poor and the vulnerable, is the responsibility of the state. That is how they are different. And more of it you will find in my notes that must be up and ready for you to go into. And beyond that, if you have questions, you can always ask again. And one person asks, do we have to learn all the articles? Oh, not at all. Not at all. I'm so glad you asked me the question. Not at all. I will tell you about 120 articles or so, and you please learn about 25 to 30 of them. And if you are even more, greedy, aspirational, it means ambitious, you can learn 35, 40. But please, I will make it extremely comfortable for you. You will learn a few articles more than what the examiner expects you to learn, and that will not add up to more than 35, 40. Rest assured. Now, uh, uh, can you please explain more rule of law, rule by law? Rule of law is a philosophy. That is, there is law. It treats all of us equally. No one is above it. It only recognizes the natural rights. That means the rights are a part of, rights are inherent in us, and so on. So it's a philosophy. Rule by law is make any law. It may not comply with the philosophy of rule of law, and you are implementing it. That's not rule of law, because the philosophy of rule of law is not found in the rule by law. For example, if there is a law saying that no one can dress the way he wants, everyone has to dress the way the government tells you, that is law. But that is rule by law. That is not rule of law. If there is a law saying that, uh, any weird feature, anyone who is seen outside on the roads after 8 p.m. will be arrested, and that is universal, not just related to pandemic, for all time to come. That is absurd. Rule by law. Courts are expected to strike it down. Did the news about Chhattisgarh taking union to Supreme Court come today? I don't know if it came today. It's been in news for the last 1 year or so. So I talked about it. As you said, Constitution is a law. Can I say an article is also law? See, Constitution is surely law, but basic law. There's a difference between Constitution and law. Constitution is a foundation, and other laws are, they have to conform to the Constitution, and they are made in the legislative capacity of the Parliament or the state legislature. And I told you there are so many laws, of which there is only one Constitution. One Constitution. And all others are laws. There is a Constitution. It was formulated in a Constituent Assembly. It is a special type of a law, foundational and sacred law. Rest all, you will have to call it law. Legislative, constituent. They are two completely different tiers altogether. Can you tell about sub-rules? You see, rules, when they are, law is there, bylaw is there. Rules are there. When you amplify the rules, you may call them sub-rules. There is no word like sub-rules. I use the word sub-rules. You don't have to use it. But rules, when they are broken up into uh, more minute forms, you call that sub rules, but don't call it. I had to tell you because law was there, bylaw was there, rule, etc. Don't use the word. How an ordinance and amendment differ. See, amendment is to an existing law or to the existing constitution. Ordinance can amend an existing law. But if you are talking of amending the constitution, ordinance cannot touch the constitution. The biggest limitation on ordinance is that it cannot amend the constitution. It can amend an existing law, it can create a new law, but it cannot touch the constitution at all. What type of country is China, as it has companies from foreign countries? See, China is an authoritarian country with a market mechanism, the market having to go by the direction set by the authoritarian government. China is, they call themselves Chinese socialism with Chinese characteristics. It's basically the Beijing consensus, that is authoritarian government, market economy, state and private companies exist together. Private companies are directed by the state in a manner that we haven't seen anywhere else. For example, take Huawei or take TikTok. They conduct surveillance on behalf of the government of China. I don't think we have such systems anywhere else. Now, is the increase in privatization of bodies previously owned by government a challenge to socialist pattern of Indian society? See, our friend is asking, when you are privatizing the railways, when you are privatizing public sector companies, when you're asking for PPP of health, is it a challenge to the socialist system in the country? See, basically socialism, even while the definition is according to the structure of ownership, you have to shift the understanding of socialism from the method to the end. Initially, we said that the government ownership is what characterizes the economic system to be socialist, part ownership. Now, why are you privatizing? You are privatizing to enhance the productivity in order to build up wealth creation, which is the precondition for wealth distribution, which is what socialism and welfare is all about. Therefore, privatization is being opted for in order to create wealth, which is the goal of socialism. So you have to shift the argument in favor of the outcomes rather than the methodology. Since 91, we've been doing it. Can you explain religious freedom in communism and socialism? You know, socialism and communism are economic concepts. Religious freedom is a part of democracy or an authoritarian political system. So I can't link the two. Nobody can link the two. Directive principles of state policy as adopted from Ireland. Could you please explain it again? In the Irish Republic, in their constitution, they borrowed from Spain DPSPs, and we saw it in the Irish constitution and we borrowed it. And when we come to the DPSPs, you will understand it. It is a historical fact that we borrowed. Is rule by law and procedure? It may be. Procedure established by law and rule by law could overlap. That is why the Supreme Court since 1978, Menaka Gandhi case, adopted the due process of law to ensure that rule by law is not allowed and rule of law with all the might of the philosophy of freedom and democracy is implemented. Beginning that Parliament will be summoned next month or maybe later this month. But why so late? Monsoon session begins only in July or early August. So is the Constitution being sidelined? No, we are in fairly exceptional times and the government hasn't breached the timetable, and July 16 is about this time. You could have the Parliament, or even if it's delayed, the pandemic allows, but ideally they should call the Parliament, summon the Parliament. With China, or does it show the lack of intent in the government? We don't know about the intent of the government. It's too early to talk about it, jumping the gun. Virtual platforms be used. We will see. When the details come, we'll certainly discuss that about the virtual parliament and so on. When you talked about colonized India, you mentioned that India was sovereign but not independent. What is the difference between, oh, this has jumped. What is the difference between sovereignty and independence? An independent country has a state which works for the people of the country, and the state is sovereign. Wherever there is state, it is sovereign. But the sovereignty of the state is serving the needs of another country in the case of a colony. Whereas in a democratic independent state, you have the state sovereignty working for the people of the country. So sovereignty is a function of the state. All countries are not independent. We were not independent before 47, but the state was sovereign. We were not independent. So a sovereign state was not serving the needs of the country. And that is the characteristic feature of a colony. Is India multinational? Multicultural? I said it's multicultural. It is multicultural. Because if you say it is multinational, then it could trigger consequences which are divisive. Difference between liberty and freedom. See, in general, they are used synonymously. But in political theory, liberty is the absence of restraint, that is, nobody will put conditions for your freedom. After a while, there'll be, so liberty is the absence of restraints, and that will create the space for the exercise of freedom. Freedom is acting according to your own volition. That is freedom. You want to walk, you'll walk. You want to talk, you'll talk. You want to do business, you want to become a civil servant, you want to dress the way you like, all that is freedom. And for the exercise of freedom, you require absence of restraint, and that is what you call liberty. So I said liberty is a precondition for freedom. That's how the linkage exists. Do we have to read about Gandhian and Nehruvian socialism in detail? Yes. Is it relevant in the current scenario? The civil service exam can take you back into history also. Why not? You read it, it's interesting. It's of course relevant. It will not take much time. It's there in our notes, economics notes, and you'll get it. What did we borrow from Japan? Procedure established by law is what we borrowed from Japan. That is what all the books of constitution say. But I thought it is a part of rule of law, and it need not be talked about. But conventionally speaking, textbooks tell you that procedure established by law, the concept I've already detailed, is what we borrowed from Japan. What was borrowed from Germany? See, you are asking these questions, they are all there in the notes. Ideally, the questions our friend is asking, constitutionalism. See, constitutionalism is the philosophy that There should be a constitution based on which governance should take place, and the constitution should limit the power of the government to enable the exercise of freedoms by the citizens and others in the country. Limit the power of the government to enable the exercise of freedoms. That is the litmus of constitutionalism. 500 days of current affairs, you advised us. We have to look at CAA and RC, of course, and other developments from around the, of course, we'll cover all that. As much as you have to cover, we will cover it for you, so you leave it to us. Difference between state and nation state. See, I also told you state and nation state will be identical because a state cannot exist without a nation. A nation can exist without a state. I gave the example of Palestinians. So you can't say all the time nation state, so you say state. State is outdated as a concept, so you call it government. So whether you call it government, state, country, nation, state, you're essentially talking about the same thing. But nation, state, and state are the same. Nation and state can be different. That is, nation is a large group of people existing together for a long period of time, sharing the same culture in a certain territory. That is a nation. If it gets a state, it becomes a nation state. A nation is a precondition for state, but a state need not follow a nation. What have we borrowed from USSR? Fundamental duties, I told you. See, these are all hyperfactual questions. They are there in the notes. We don't have to spend additional time on that. I would love to have questions which trip the candidate. You know, I would like to have analytical, conceptual questions. Pure facts are there in the notes. Since UK is a constitutional monarchy, it is not a constitution. Where is the constitution in the UK? But you can still, okay. Is it considered as a sovereign state? Yeah, of course. All states are sovereign. There is no state without sovereignty. Can Queen veto the laws? You mean sovereign parliament. You must be meaning sovereign parliament. Can a queen veto? So how are you linking sovereignty with veto and all that? Even if the queen vetoes, how does it impact the sovereignty? Sovereignty is the property of the state, of which queen is a part, parliament is a part. According to secularism definition, principle of separation of the state from religious institution, how secular India can be seen? See, secularism is a goal. We have the constitution and laws. We have the judgments that establish the country as a secular country, but our compliance with the principles of secularism has been evolving. That is a goal, and it is a goal that we will one day achieve. And in the process, we keep learning about secularism, education, law, judiciary, civil society. They'll strive to make the country secular because there is no other way to be in the country. We have to respect each other and the religious identities. Does the compatibility of the laws in and with the constitution change according to changes in the social beliefs? Yes, it does. I told you about sati, dowry. I told you about instant triple talaq. If yes, what about the orthodox morality? Orthodox morality is giving place 377. It's not article. It is section 377 has been considered. Criminalization is considered unconstitutional. It is decriminalized. Can we still ensure the protection of with the existence of see, one is about attitude, the outlook, the mindset, the habit, the value, the bias, the stereotype. The other is about the law. Law in course of time will cleanse our attitude. Constitution creates the conditions for it. And over a long period of time, we will all be fine. And in the meanwhile, law can be ahead of your values or law can be behind your values. And in course of time, they level out. Law is behind your democratic value in your section 377. And when is law ahead of your values? Law can be at times ahead of your values. For example, we need to be secular. We have no choice but to be secular. And in the process, if we are unsecular in our attitude, law will compel us to be secular. In course of time, we get habituated to become secular. What differentiates our armed forces? Yes, armed forces are a part of state. What differentiates constitutional laws from other laws like the IPC? What is GST? Constitution is there. Constitutional law is what judiciary adds to it. For example, basic features are constitutional law. Collegium is constitutional law. What the judiciary adds to that is constitutional law. GST is added by the parliament and the states. That is a part of the constitution itself. IPC is a law. Indian Penal Code is a law, and that has to be compliant with the constitution. It is. Tomorrow, if you amend it, it will still have to be compliant. Otherwise, the courts will come down. So IPC is a law. GST is a part of the constitution. There are some laws related to GST authorized by the constitution. And constitutional law is a concept which says that whatever judiciary has added to the constitution is the constitutional law. How is the government of India sovereign if there is judiciary and parliament there to keep a check on its powers? Government of India is not state. Government of India functions on the basis of the constitution. The constitution gives them, constitution is sovereign, constitution creates them, constitution gives them powers, and there is no authority that can go above the state. For example, between parliament, president, and the judiciary at the national level, at the state level, there is no authority higher than them. Constitution tells them their powers, and they can exercise their powers. And there is no authority higher. Parliament is not higher than Supreme Court, nor is Supreme Court higher than Parliament, nor is President the highest. All of them together make the state, though judiciary technically is outside the definition of state, that is for a certain specific reason, though not substantially. They're all state and no one is higher than them. Between the three organs, they check and balance each other so that there is orderly governance. Once the parliament session starts, can ordinances priorly made be challenged? Yes. Once the parliament comes, the session starts, the ordinances can be withdrawn. I mean, the parliament can defeat the ordinance as ordinance. They can pass a resolution saying the ordinance is no longer required. They can also, when it comes in the form of a bill, parliament can defeat it. It doesn't happen, but it can happen. We have said that India is a federal country with unitary features. India is a union, but Article 1 defines union. I didn't say union. I said unitary. Union is not the same as unitary. We will see it when time comes tomorrow, day after. If we Indians have the right to life, then we should not hang or give capital punishment. But Article 21 says right to life and personal liberty can be deprived by following the procedure established by law. So law itself allows deprivation of life by due procedure established by law. Why we would not just copy a constitution from a country having the best constitution at that time? It will be implemented early. And is it okay to copy any article from? There are no intellectual properties attached to them. Not then. We don't know about today. If tomorrow your right to information law is copied by, let's say, Zimbabwe or Argentina, will you take them to International Court of Justice? Will you take them to the WIPO, intellectual property? No, no, this is public property. This is idealism, open source. Anyone can copy from anywhere. Do we have a committee which keeps an eye on what changes are going in other countries? So something is good, we can adopt. Why not? I've just answered. You find a great feature. The fact that you are copying it is a compliment to them. The world will look up to them. So that's goodwill, that's soft power. How can the courts enforce unwritten conventions? Some conventions can be enforced. That is up to the courts. If they choose to enforce them, they may think of enforcing. For example, Dr. Manmohan Singh became Prime Minister. He was a member of Rajya Sabha. It's a convention that the Prime Minister should come from Lok Sabha. Courts chose not to enforce it because it's a decision of the democratic will of the people seen in the electoral outcomes in our representative bodies. So courts may choose, may not choose to operationalize the conventions. If we Indians have the right to life, then we should. Okay, that's been answered. Can you tell me about the link for chapter uploaded in ebook? You'll all be notified. They are not for me. So have I answered all your questions? Looks like I have. We'll come back tomorrow. God bless you.